Well, I wanted to do this today to recognize a fairly momentous occasion in the annals of Wichita criminal history. The Carr Brothers decision today came down from the United States Supreme Court. It came down in a fashion that is consistent with the state's position on this case, and that is that the appropriate sentence was handed down by a panel of citizens from this community many years ago. Just to sort of set the stage again, go back through two or three of the main issues that were presented by Kansas and handled by the court today. First of all is I think what folks would refer to it as the joint trial, the fact that the two individuals were tried together, and that was one of the bases upon which the Kansas Supreme Court overturned the sentence. The idea being that while they were able to be tried together effectively and legally, the sentencing phase should not have been tried together. That was what the Kansas Supreme Court ruled. And the United States Supreme Court ruled that that was not in fact the case, and that there were any number of reasons to try cases together, and that the manner in which this case was tried and the joint trials did not deprive either individual of a fair process under the Constitution of the United States. The second issue, I'm just picking them out, they're not necessarily sequential, but the second issue had to do with an instruction. The risk of getting a little too much in the weeds here, I'll simply say that a jury must decide beyond a reasonable doubt that aggravating factors exist if they're going to impose the death penalty. The question is, what burden, if any, how is the judge to instruct them as to any burden with respect to mitigating factors? So as they're balancing, did the state prove aggravators? We have to prove beyond a reasonable doubt that they exist, and prove beyond a reasonable doubt that they overweigh or outweigh any mitigation. And it's very difficult to explain this in a simple way, but the Supreme Court of Kansas had ruled that Judge Clark needed to be more explicit in instructing the jury, telling them that just being more explicit, more direct about what their burden of proof was with respect to the mitigators. And they couched their determination in the Constitution, said the Constitution requires it. The United States Supreme Court today said it does not, and that there could be no misunderstanding from the jury what their burden was and what's required. I'm going to try not to summarize the opinion too much and inject my own opinion into things, but essentially what they ruled is, how does one instruct a jury about how to apply mercy? That's really what, at its root, mitigation is. A jury has the ability to grant mercy to somebody, and the idea that there needs to be an explicit instruction about how to do that seems antithetical to the entire notion of mercy in the first place. It's maybe a little anecdote on my part, maybe a little bit of my own opinion in reading that, but that's certainly the takeaway I had from the opinion today. So those are the two big issues, and that's what we went up and argued before the United States Supreme Court. Derek Schmidt handled the instruction component. Mr. McAllister, he's a professor of law here in Kansas. He's also he was the one that handles a lot of the death penalty cases for the state. He argued the joinder, the severance issue. There was a third issue which we asked the court to take up. They did not, and that's, again, at the risk of being a little in the weeds here, it's called the Crawford issue. It's a hearsay question. Crawford was a case that came down in 2004 that talked about how much hearsay, or how hearsay can and cannot be admitted at trial. Bottom line is, the Supreme Court of Kansas didn't necessarily overturn, it must be mine, excuse me. Somebody turned their phone off, right? So, about whether or not hearsay can be applied and how it's applied. The Kansas Supreme Court, in overturning the sentence initially, ruled or sort of mentioned the fact that the Crawford decision may have been implicated, but they didn't explicitly overturn their decision based upon that. As a result, the United States Supreme Court did not explicitly take up that issue. Many of you listened to or read the transcripts of the arguments at the United States Supreme Court, and will remember that Steve McAllister mentioned in his final comments to the court that we would ask them to at least address that, because we don't want to end up coming back, winning these two issues, and then still have an issue that was left unresolved. I would simply point out that I believe it's on page 17 or 18 of the opinion today, the Supreme Court, essentially, the United States Supreme Court took Mr. McAllister up and said, again, the Supreme Court did not make the admission of those statements as a basis for its vacating of the death sentences, but merely cautioned that when it was if a resentencing was to take place, they should not be admitted. Here's the quote from the United States Supreme Court. "We are confident that cross-examination regarding these police reports would not have had the slightest effect upon the sentences." So there's a strong argument that even that third issue that had not been taken up directly has now been resolved by the Supreme Court in their handling of this ultimate opinion. So again, some of this is fairly in the weeds, legalese, but the upside is, or the takeaway is that in all respects, all of the issues that were briefed, all of the issues that were raised by Attorney General Schmidt and his team were resolved favorably to the state of Kansas today. The question I'm sure everybody asks is, what's next? The case was remanded, which is kind of a fancy way of saying sent back now to the Kansas Supreme Court for, again, the words they use is for handling or for proceedings that are not inconsistent with this opinion, meaning go back and pick it up at this point under Kansas law, but this decision will control. So what does that do? The attorneys for the respective defendants will now make any additional legal arguments they want to try to make. At some point there will be what's called in legal circles a collateral appeal, a collateral attack on the case, which is typically under state law, 1507 is what we call them. That's where somebody raises arguments about the effectiveness of their counsel, things like that. But in terms of the direct appeal, was sufficient evidence raised? Was a fair trial granted? Were there trial errors that took place within the confines of the trial? Those issues have been resolved at this point. And so this is a significant event in the course of the Carr Brothers cases, having gone from the work of the Wichita Police Department and specifically Lieutenant Ken Landwehr and his team to get us to this day through the trial, and Ms. Folston and her team, Judge Clark, who I would be remiss if we didn't mention, in his handling of the trial itself, Attorney General Schmidt, Steve McAllister, all the appellate attorneys from our office, all the people who worked on this to get us to this point today where the United States Supreme Court has ruled that the case was handled appropriately and the jury's verdict was not in contravention of the United States Constitution. So I'll answer any questions, but that's a summary of what happened today.
It's been over 15 years since the original sentencing to get this far. Now down to possible collateral appeals. Any concept of how much longer this case could continue to be in the courts?
No, I mean, death penalty jurisprudence, capital murder jurisprudence it's a marathon, not a foot race. These things aren't handled overnight, and they're not handled in short order. And I think that is, as frustrating as that may be for people, I think it's also probably the way it ought to happen. There ought to be plenty of time for careful consideration to make sure no errors are uncovered. And I'm not talking about this case, I'm just talking about capital murder jurisprudence. So I think the message, though, for citizens and people watching, listening, reading your various organizations is that this office, certainly as long as my name's on the door, and I have confidence that no matter whose name would be on the door, that they would bring the same level of determination to make sure that we see it through to whatever end it will have. Whether that's 2 years, 5 years, whatever. Somebody from this office will be ready to stand up in a court if that's what it takes, to see to it that the justice is served.
Are they at the front of the line in terms of death penalty cases?
Well, it'll be so Mr. Robinson from Johnson County was the first case that was sustained or affirmed on appeal. That was just this last fall by the Kansas Supreme Court. So in terms of just sequentially, Mr. Robinson's case happened to come first. While this case, the Carr Brothers case, was overturned, it's now essentially in the same equal footing, same place now as the Robinson case. It comes back having been affirmed, granted by a higher court than by the Kansas Supreme Court. In terms of who goes first, I'm not going to get into that. We're still ways away from that. But we now have two cases, though, where the sentence that has been imposed has been affirmed by one court or the next one up.
And who determines, once all appeals are exhausted, that it's time to set a date for so-and-so's execution?
Well, the simple answer is I don't have any experience to draw on to answer that. We haven't done it since 1965, so I would say that like any sentence, once someone has completely exhausted their appeals, the sentence is imposed. Now, in most cases, that simply means that they quit filing appeals and they simply serve out their sentence, whatever that may be. In this case, the sentence is a death sentence. So at some point, when all of the appeals have been exhausted, it'll be up to the Department of Corrections, probably the Secretary, to contact, to set a date for execution. That'll trigger a final set of reprieve motions, I'm sure, to the governor, whoever that may be at the time, and ultimately to any other courts seeking a stay. But at least that's how it's done in other jurisdictions, and I think how it's contemplated under the Kansas set of laws. Anyone else?
This case has made national news. Have you gotten contacts from any outside of the Wichita area?
Well, candidly, I've been running from one meeting to another today, so I'll have to ask Dan when this one's over with. But I'm sure AP is called. I don't see her in here, but I wouldn't be surprised if others. But I don't know. If there's nothing else, I don't want to cut anybody off. I guess go ahead, Amy.
Have you had any contact with the victims' families after this decision came out?
I think David sent me the notice that it came out at 9 o'clock Eastern Time, which would have been about 8:01 Central, and by 10 after, Georgia had reached out to all the victims' families. We'd made a call to Ken Landwehr's widow. We'd gotten word to Judge Clark's widow, or tried to at least, and made sure that everybody who had a pivotal role in this case had been notified.
Can you talk at all about whether there was any kind of reaction or whether any of the thoughts from any of those people were today?
Pleased, I think is a simple way to put it. That was the last comment I was going to make. I'm very appreciative of the fact that I get to sit here and be the one to explain this to the citizens of the county I represent. But my role in this has been late in the game. I remember that morning quite well. I was working here. I actually had the other quadruple murder assigned to me at the time. So, but again, not to overstate it, but I saw the work that morning that went into the investigation of the case from Lieutenant Landwehr, from all of the detectives who worked that case. I saw the effort that went in. This room where you're sitting right now did not look like this at the time. It was a storage room, and every piece of evidence in this case was stored in this room in anticipation of trial. And Ms. Parker and Ms. Folston, and later Mr. O'Connor, when he came back from D.C., worked in this room. Kim and Aunt Nola were in here every day for hours, for months, in getting ready for the trial. Saw what it took to get the trial to that jury. Went up and watched moments of the trial many times. I remember standing in the foyer out there, watching our little TV in our victim's room, watching the live stream from one of your agencies as Judge Clark read not only the verdicts but also the next day the the sentence, because it went very quickly. So I guess my point is being clear about my role in this, which is to simply carry it through, rather than take, how to put this, rather than to take credit for something where credit belongs to others. I will presume, at least in having the history I have with this case, to say this: the relief those families must have felt to get this was palpable. And the idea that HG won't have to come back and testify is why I'm sitting here right now. That's worth having a press conference. That is a good thing, no matter what happens at this point. If she doesn't have to come back and testify, that's a good day for Wichita. Okay? Okay, appreciate all your time, and if any of you have any questions about the kind of wonkish, in the weeds stuff on the opinions, if you want to get into that, let me know. I've got only 2 more meetings yet today, so I got all the time in the world, all right? 3 actually now. All right, thanks,
Marc.
folks.